Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Welcome, everyone, to another edition of the Empowering Plans Podcast. My name is Corey Crigger. I'm your host today, and I'm excited to be doing this podcast once again with a new co-host, someone that I work with every single day, but I've not podcasted with yet, Brian O'Hara. Brian, how are you today?
Corey, I'm doing great. Great to be here with you. This will probably be the first and last time that we ever record together. So, I can't imagine them letting us do this again. So let's enjoy this.
The monkeys are truly running the zoo, and Brian
Indeed.
doesn't know what I'm getting ready to say, but I mean every word of it. I enjoy these podcasts. I enjoy doing the podcast with everyone, but I personally believe that the podcast is better when you have good rapport with who you're with on the other side. And I can honestly say that since I've been at FIA, Brian is one of my favorite people to work with. He is always the first to help out. We're both in the provider relations department. This is going to be a very provider relations heavy podcast today, talking about the NSA, talking about some balance bill safeguard stuff. But Brian has been a great friend. He's someone that I enjoy working with, and I really am going to enjoy doing this podcast with him today. So hopefully you'll have some fun and there'll be some information in here.
Thanks for the kind words, Corey. I appreciate it. I wish I could say the same, but no.
I really left myself open for that one. In all seriousness, though, this is going to be a very NSA-heavy podcast. We're here to do public service announcement on the NSA, the PSA on the NSA. There's a lot of stuff going on in the IDR process. But, Brian, last week, I just got such a great result, and FIA got a great result for a client and for a patient on a balance bill safeguard file that I'm going to take just a couple minutes to talk about it here. If you're out there and you're listening and you're following FIA on LinkedIn or on Twitter or following us on Facebook, I'm sure you saw the blog post that went up that I did a very small write-up, but you're just going to have to humor me. I'm going to go through it again because I do think that this is just a great result that we need to highlight. For those of you who don't know, you should know, our balance bill safeguard product is the product that guarantees a health plan will never pay more than 200% of Medicare on a balance bill. How are we able to make that statement? It is because if it settles for more than 200% of Medicare, then FIA will be on the hook for the amount over 200% of Medicare. It's an excellent product that gives groups a great peace of mind that they are going to be able to cap expenses on balance bills. And a couple years ago, and it really wasn't too long after we started the safeguard product, we got a very big claim in. It was a large claim. It was almost a $700,000 billed charge for a 2-month NICU stay for a premature delivery. And just to be, frank, it was hard fought for this child. He was in the NICU for 2.5 months at a large health system in Texas, and he was eventually released, and he was released home. And that in of itself is a blessing. Fast forward a little bit, though, and this family received a balance bill for $580,000. The plan paid over $120,000 for an initial payment, and this health system in Texas balance billed for $580,000. The patient did exactly what they were supposed to do in their program. They submitted the balance bill to their patient advocate. It went through the process and it ended up at our desk here at FIA. And without boring anyone with too many details about benchmarking claims and looking at claims data and looking at fair market value and zip codes, we determined that a fair offer to resolve would be, about another additional $50,000 based on everything. And it took a long time to get that result. It took a long time to get us across the finish line. But last week, the provider agreed to and accepted the additional payment as payment in full. It settled for right at 200% of Medicare, which the plan was going to pay regardless. But more importantly, it was able to help a family shut the door on a very painful chapter of their life. And now they do not have to worry about this balance bill anymore. The group was never going to have to worry about paying that exuberant cost if it did settle for more. FIA was really exposing itself to a lot of potential liability here, but we trust our process, we trust our team, and we can get great results. And that's why we can offer such a great product like Balance Bill Safeguard with that 200% of Medicare guarantee. So if that product is interesting to you, if you want to give your groups the peace of mind that this group had, if you want to give your plan participants the peace of mind that this family now has, you can reach out to me. see Crigger at FIAgroup.com for more information about the Safeguard program, or any of our representatives at FIA will be able to talk to you about that. But Brian, that was just such a great result. I feel like we had to start there for a minute. Is that all right?
Absolutely. Of course. And I mean, that's a great story, obviously unfortunate circumstances behind it. But, if you think about, ultimately what FIA's goal is, it's to make healthcare affordable for employers and their employees, correct? And this product, this service allowed us to, in a small way, achieve that goal. So that's really great to hear.
Absolutely. Absolutely. It's a great story and it's a great result. And that's why I wanted to bring it up here. But now let's get to the show. Let's get to what we're really here for, the PSA on the NSA. Brian, we want to do a public service announcement about the NSA, and we have been inspired by the 15 to 20 second commercials warning us of the pitfalls of life. Things like, this is your brain on drugs. Things like just say no. Things like only you can prevent forest fires. These things that we grow up with embedded in our mind. There's a lot of things that we have people to warn about the NSA and what we're seeing in the IDR determinations. But Brian, I listed 3 of the big public service announcements that stand out in my mind. What are the ones from your days past that you remember?
Well, certainly one of them is another environmental themed one is give a hoot, don't pollute, of course. And then this one might be a little before your time, Corey. I know I'm a couple years your elder. The like father, like son commercial, where the father finds some objectionable substances in his son's room. And he asks, how do you learn about this? And he comes back with the iconic line, I learned it from watching you, Dad. That one certainly sticks in my mind.
This is the content that you can expect when Corey and Brian get together on this podcast. Is Ron Peck and Brady Bizzaro giving you top 5 lists of public service announcements from 30 years ago? Absolutely not. They're not here for that, but Brian and Corey are here for that. And if only we could lead into the NSA with Sarah McLachlan trying to get us to adopt a pet, it would be the perfect segue. But we don't have that kind of funding. We can't pay for that copyright, but what we can do is actually get to some content that the people are here for. Brian, you are our resident NSA expert. You have been on the front lines of all these IDR determinations. The NSA was supposed to provide this kind of streamlined assembly line way for plans and providers to not balance bill patients and come to reasonable ways to resolve disputed claims. And it was going to be this magical IDR process, and honestly, it seems like it's been anything but. Tell the people what you're seeing, tell the horror stories, tell the people what they need to be aware of to make sure that they have a good solution in place for these NSA claims.
Sure, absolutely. And I mean, I don't want to completely bash the NSA. I mean, it has achieved its goal ultimately of preventing surprise bills on patients. We have to remember that the No Surprises Act is at its core a patient protection statute. It affords certain procedures for plans and providers to kind of play nice and resolve their disputes. But ultimately, the goal was to protect patients, and it has achieved that. But I mean, this is a government process. So it makes sense that there's going to be some hiccups along the way, right? And certainly we've seen some hiccups. Obviously, right now, most people are aware that the IDR is paused. It's been paused a few times based on some challenges made out of Texas. It currently is paused again. I'm not going to get into the details of that. What I kind of want to talk about are some of the issues that we've seen on the ground floor.
Brian, before we go any further, you mentioned the Southern District of Texas there. That is where all these halts are coming from, it seems like. It seems like we got a district that is very willing to throw the brakes on and feel like that they are empowered to kind of rewrite the process, or at least attempt to put HHS and CMS back to the drawing board on a lot of this. Do you agree with that? Am I oversimplifying it?
I mean, I would agree with that. It's certainly, I think, a little bit of forum shopping on their part, which I think is smart for them, to achieve their goals. But, we have to work within the confines of the process, and that's kind of what we're doing. But there probably are, admittedly, some aspects of the NSA that need clarification, and, we're getting a little guidance out of it at least. So as far as kind of, the ground level things that we're seeing, one of the biggest issues with IDR is the concept of notice. And what do I mean by notice? Well, in the American judicial system, notice is really one of the most fundamental requirements of due process, right? Corey, if you're going to sue someone, you kind of have to let that person know that you're suing them. If you're being sued, you'd appreciate if the person let you know that you were being sued. Why? Because you want to be able to show up to court and make a defense. It only makes sense. And, IDR is kind of like a quasi-judicial proceeding. You have the two parties. You have the IDR entity, which is kind of like the court or the judge in that situation. So the notice requirement really is the same. And the NSA does prescribe a process for notice. Obviously, you have your open negotiation period where the parties are free to come to an agreement. But if they can't, then the case goes to IDR, right? And with IDR, independent dispute resolution, you have the initiating party and the non-initiating party. 99% of the time, the initiating party is going to be the provider, because why would a plan challenge its own payment? The way notice is provided is the initiating party submits its dispute through the federal portal. They include the non-initiating or plan's contact information, including their email address, and the portal automatically notifies the non-initiating party that a dispute has been filed. At that point, they have a chance to their initial response, so they can make any initial challenges to the eligibility, request their preferred IDR entity, and then eventually submit an offer for consideration. What we're seeing is that providers are routinely using the incorrect email address when initiating IDR. Whether this is on purpose, whether this is a mistake, it's tough to tell. Ultimately, it doesn't really make much of a difference, because what's happening is we're seeing default judgments against plans because they weren't able to submit an offer. One of the issues that we have is that there is no tracking system for open negotiations, right? Open negotiations come directly from a provider. So there's no provision for the government to track these open negotiations. So if you don't receive a notice of IDR by the time the IDR deadline comes, there's really no way to determine if a provider elected not to file or if they just filed using the wrong contact information. And what's happening is, like I said, we're getting these default judgments, and there's really no defined process for challenging determinations that are the result of notice deficiencies. And it creates this massive administrative burden getting these matters overturned. We have had some success with that, but what we're finding is that there's really two kind of governing bodies that you can contact in these situations, correct? There's the TRI departments using the federal IDR questions email address, or there's the IDR entity itself. Good luck contacting them. Generally speaking, you can't call either one. You send an email off and it kind of goes into the ether, never to be seen again. If you do get a response from one of these entities, they usually just refer you back to the other entity. Federal IDR question says, this isn't appropriate for us to handle. You need to contact the IDR entity. The IDR entity says, this isn't appropriate for us to handle. You need to contact federal IDR questions. As an example, I was negotiating with a neuromonitoring provider out of New Jersey. The provider, unfortunately, wouldn't negotiate in good faith. They were asking for reimbursements that were many, many times standard reimbursement rates. The plan had done everything right. They had the proper NSA disclosures on their explanation of benefits and explanation of payments, including the appropriate point of contact for IDR. I further contacted them several times, reminding them where to initiate IDR, the correct email address. Well, the deadline for IDR came and went. No initiation occurred. So I contacted the provider just to do my due diligence, make sure that there's no IDR. The provider initially refused to answer. Eventually, they confirmed, yes, we did initiate IDR, but they refused to say where they sent it, what email address they used, what the dispute number was, or the name of the IDR entity. Basically saying, yes, there's an IDR initiation out there. There's an active dispute. We are not going to tell you where it is, who's handling it, or any information regarding it. So,
Brian, one could say it's 10 o'clock. Do you know where your IDR entity is?
Indeed. And I am the shameful parent that has no idea where the IDR entity is in this particular situation, unfortunately. And, this was a situation where I spent literally months trying to locate the IDR entity and the dispute number. And by the time I was able to locate that, decision had already been rendered. So naturally, if you were to get a default judgment in the mail against you, Corey, you would immediately go to the court and you would say, look, they did not provide me notice. And the court would say, well, okay, initiating party, give me proof that you gave him notice. And when the initiating party couldn't do that, the court would dismiss it immediately. Well, In this case, the IDR entity claimed that it didn't have authority to dismiss, and they referred me back to federal IDR questions, which referred me back to the IDR entity. So right now we have this default decision really out there. So it's kind of like, well, what's the solution really? And unfortunately, it's not a perfect situation. The NSA, it doesn't really have any real enforcement measures. So if the provider wanted to enforce this decision, it would have to sue the plan really in order to make the plan honor the decision. If the plan elected just not to pay, at that point, the plan could raise those notice issues at that time. But of course, this creates a huge expense and a huge administrative burden. What I would like to see is some kind of tracking system for open negotiations, just like disputes are sent from a portal. If we could have open negotiations sent from a portal and assigned a tracking number, then when that IDR date comes and goes, you could look up that tracking number to see if it was actually assigned a dispute. Whether or not that happens, we'll see, but I think it's something that would be helpful in the future. Another issue that we've seen, now that we're further into this process, we're seeing more and more final determinations from IDR entities. And frankly, they're a little enigmatic. Beyond the QPA, IDR entities have 6 general factors that they can consider when deciding between the initiating party's offer and the non-initiating party's offer. They have the training, quality, experience of the provider, the market share held by either provider or the plan in the geographic region, patient's acuity, complexity of care, the teaching status of the provider if the provider's a facility, demonstration of past efforts of either party to enter into a network agreement, and then generally any additional information that's not otherwise prohibited. And these IDR determinations are coming out. They'll include a grid that literally lists all 6, and they'll have an X next to each party's submitted evidence on. But they don't actually give any information as to what factors they considered important, what they didn't consider important, or really the weight that the IDR entity placed on any one of the factors. The language that you'll see will often say something like, the initiating or non-initiating party's offer best represents the value of the services that are the subject of this payment determination. Well, that's great, but why? How did you decide this? What was your reasoning? And, we need to know that for a number of reasons. First, if we know how the IDR entities are thinking and how they're making these decisions, obviously we can tailor our final submissions to reflect those guidelines that they're using. More importantly, if we know how these IDR entities are ruling, we can give our clients better advice on, how to proceed during open negotiations. Hey, IDR entities really give a lot of weight to teaching hospitals. This is a teaching hospital. Maybe you should consider giving a little extra money. Maybe that will, in this case, have you avoid all the expense of, and hassle of going through IDR. So it's really frustrating that we're not really getting a lot of information from them regarding, their reasoning behind their decisions.
Brian, and without knowledge, we can't get any better. And we all know that knowing is half the battle.
Yes, we do. Sorry, I needed a second there to sigh at that terrible PSA, but I do secretly love it as well. One last thing I'll say, this is just kind of, an example of some of the frustration that we're seeing. We're also getting some nonsensical decisions. A colleague of ours recently received an IDR determination that found in favor of the initiating party, but it also found in favor of the non-initiating party. I'm going to read verbatim what this said, though I'm going to de-identify it so that, none of the IDR entities or anything are named. It literally said, after considering all permissible information submitted by both parties, the IDR entity has determined that the out-of-network payment amount of $1,342.70, that's a made-up number, offered by the initiating party is the appropriate out-of-network rate for the service on this claim. The very next line, the IDR entity has determined that the non-initiating party's offer of $812 best represents the value of the qualified IDR service at issue in this dispute. Therefore, the IDR entity has determined that the non-initiating party has prevailed. So I think what we're seeing is the result of the burden that these IDR entities are under. They're very far behind, so their decisions are very sloppy. There's not a lot of good information. And once again, in this situation, the NSA doesn't really prescribe any kind of process to appeal or challenge a final determination. So both parties are left at the mercy of the tri-departments and the IDRE to, hopefully respond with some kind of definitive solution. So those are some of the biggest issues that we're seeing right now. There are others. I don't want to give the impression that, the system is completely broken. It's just there are issues that need to be worked out. Luckily, FIA has been on the forefront of NSA direct negotiations and IDR since the very beginning. So I hope that we're influencing the process to the benefit of our clients to the extent that we can.
Absolutely. And I think, Brian, you really nailed a great point there at the end about the strain. It was forecast incorrectly how many claims were going to go into this IDR process. I think in May, CMS published a paper saying that there were 17 times more claims submitted into the IDR process than what was forecasted, which was one of the factors of why they attempted to raise the fees to get a claim into the IDR. And of course, call back to earlier in the podcast, we talked about that Southern District of Texas said that fee raise was incorrect, and that put another halt on the process altogether. So this has got the patient out of the middle, but it does have its growing pains. And FIA, of course, is on the forefront like it is on any other piece of massive legislation, whether it be the ASA, the NSA, or any other three-letter acronym. We're here to provide support to our clients. Brian, I've really enjoyed our time together here. I think we're living proof that you can learn something from a couple of dummies. Hopefully you out there in podcast land have learned something as well, and you enjoyed your time here with Brian and I. We are going to send it off now, and we just want to remind everyone to have their pets spayed and neutered. Thank you, guys.
Rest in peace, Bob Barker.